That's started at May 23rd of 2022. There was a motion to adjudicate probation filed. She entered pleas of true to counts 4 and 5.
Pause here because this isn't just procedural housekeeping. A motion to adjudicate probation is one of the most dangerous moments for a defendant. It means the court is deciding whether grace runs out today. Probation isn't a second chance anymore, it's hanging by a thread.
Does the state have testimony with regard to counts 1, 2, and 3?
Yes, the court would like.
Yep, I think I would.
Young man called, Ms. Shakita Cole.
Yes, ma'am. Good morning, Ms. Cole. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Ms. Cole, would you please state your full name for the record?
Shakita Cole.
How are you employed?
I'm employed at Jackson County Adult Probation.
And as a adult probation officer, is it your responsibility to supervise an individual on this probation by the name of Devin Atkins?
Yes.
Do you see Ms. Atkins in the courtroom here today?
Yes.
Can you point to an identifier?
Right here in the blue jumpsuit.
Your man of record reflect Ms. Cole has identified the probationer Devin Atkins.
Record will so reflect.
And Ms. Cole, as with every probationer, when they are placed on the court's probation, are they given the rules and restrictions placed upon them and what they are supposed to do to follow the court orders?
Yes.
And each one of those in detail is gone over with them so that they understand everything that they're required to do.
Yes.
Was Ms. Atkins so advised?
Yes.
At her intake?
She was advised at her intake and at a TTM at the Melton Center in Perkins.
Okay, and describe for the court what a TTM is.
A treatment team.
Okay, so in your opinion, Ms. Cole, as her probation officer, was Ms. Atkins fully apprised and aware of what she was required to do on probation?
Yes.
And were in fact a majority of those things intended to help her?
Yes.
Was she advised that she was to report to the Community Supervision Department when directed by yourself in the court?
Yes.
And did Ms. Atkins, based on your review of the file, fail to do that on...
This is textbook prosecution strategy. The state isn't rushing, they're documenting every missed report, every failure to notify, every unchecked box. This is called laying the foundation, and once it's built, the judge has very little room to ignore it. Paper trails win probation hearings.
multiple dates, including but most likely not limited to November 4th of 2024, November 19th of 24, and was that in violation of her probation order?
Yes.
Did you address that with her and inform her it is important to report if you have something come up you need to let me know?
Yes.
And did she do that?
No.
Was Ms. Atkins, as a condition of said probation, ordered to perform community supervision hours?
Yes.
And to report those to you?
Yes.
Obviously, if you do not know that she has completed them, even if she has, is that a violation of her probation?
Yes.
To your knowledge, based on your review of her file and your supervision of her, did she either complete the hours or immediately report to you? Sorry, I'm reading. No wonder everyone's looking at me.
I was about to.
Well, that is in fact a condition of probation, right? Is it also a condition of probation that she is to report to you as her address and so that you know where she is all the time?
Yes.
And if she does not do that, is it impossible for you to locate her?
That's
And
correct.
did she in fact immediately report to you her current address?
No, she did not.
Anything else? I know you and I have had a lengthy discussion about her that you feel would be appropriate for the court to know in conjunction with your testimony and your updated PSI.
The main thing is her mental health. She refuses to address that. We've made appointments for her with Spinal Tap and she didn't attend the appointments. She's 100% when she was out unmedicated. So
This is the turning point. When mental health enters the record, the case stops being just about rule breaking and starts being about capacity. Notice the probation officer's tone. It's not punishment, it's exhaustion. The system tried, and now it's asking the court to decide what happens when help is refused.
that kind of interfered with her completing her services. And she maintained contact with the victim in the case. So that part, her grandmother was trying to be there for her because of the mental health difficulties. And that's the main thing that we were trying to get her to address.
Okay.
Can I address anything?
In a minute. Mr. Lewis, do you have any questions? Hold on, ma'am. You're going to get an opportunity, okay? Mr. Lewis, do you have any questions of Ms. Cole?
Just briefly, during your supervision of Ms. Atkins, was you able to supervise her at points when she was on her medication and not on her medication?
The entire time she has not been on her medication.
So she's been on medication this entire time?
Yes, sir.
Anything else?
Nothing else.
All right. Thank you, Ms. Cole. Any other witnesses with regard to the allegations? Based on the testimony,
Unless I may ask, Ms. Cole, Judge,
Yeah.
and you stated that earlier, Miss Evelyn Thibodeau, I believe that is her grandmother, correct?
Yeah, scrapping.
hold on, ma'am.
At some point in time in November of 2024, was Miss Atkins violating the condition the court had imposed that she not to have contact with Miss Thibodeau for Miss Thibodeau's sake?
Yes.
Any questions about that? About
No.
the count, that's count A with the contact, okay. Then, at this time, based on the testimony, I am going to find counts 1, 2, 3, 6, 7, and 8 true. Again, there were pleas of true to counts 4 and 5 previously. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, ma'am. Judge.
Any additions or corrections to that report?
No, from the bench, Judge.
Nothing from the state, Your Honor, unless Ms. Cole has something to add.
Do you have anything to add that's not already in your report?
Yes.
So the main thing I want to make sure, Ms. Cole will have a notation here to ask is, you guys were aware of mental health issues and had opportunities for Ms. Atkins to participate in mental health services. Is that correct?
I made the appointments myself.
Okay. All right. Argument, Mr. Lewis?
Well, Judge, I think definitely from the updated PSI we have, as well as I think there was some issues from the jail. If you look at those issues and activity, I think that goes directly to her mental health state. Unfortunately, she has not been on a mental health caseload. I think that definitely would benefit her, as well as, being able to take advantage of any services that spinal tap MHMR may have, or any programs that probation deemed appropriate for her. I have had conversations with her, and meaningful conversations with her, where she has addressed to me her desire to take advantage of those activities if those available to me. She did understand that she had the safety opportunity that didn't go well, but I don't think the mental health issues were addressed, mainly just substance abuse at that point. I think if we can get a handle on that, or get some work done with her too.
Here's the disconnect that traps so many defendants. Devin hears mental health evaluation and thinks label. The court hears untreated risk. Question for you: where should responsibility end and accommodation begin? And who pays the price when that line isn't crossed in time?
Address the mental health issues. I think she would do a lot better in this situation. It's critical to complete this assessment.
I mean, it's hard when
Hold on.
someone's not taking patients.
Well, it sounds like you had appointments that you missed that Ms. Cole made for you. What, did she go to regular Safe P or special? Hold on.
Special needs.
So she's already been to special needs
Okay.
Safe P. So that was a whole 6 months plus aftercare of drug and mental health help. So Ms. Atkins, the problem is you're being given all the opportunities.
Yeah, but like I said, I don't know if I told you, I had an appointment in Port Arthur because I cannot get into enrollment. They're not taking new patients.
So you had an appointment that Ms. Cole set for you, at least one. How many?
Yeah, but it's not for medicine. It's for psycho. I'm not a psycho. I don't have those problems. I mean, some people do that. I don't know.
Well, you obviously we don't know what you need because you won't even go do the evaluation. That it sounds like you haven't been on medication that would be what?
Evaluation where?
At Spinal Top.
That's what I'm telling you. That's not. I don't have that. I'm not a psychopath. That is for.
It's psychopath. Nobody's saying you're a psychopath, but you
That's what
have.
it's called PATS program. I'm not a psychopath.
That's not what it's called, and that's not the reason it's called that. Okay, if you had gone to your appointment and talked to them, then you would know what that was for, and you would know that it was meant to help you so that you could get on medication, stabilize, and not have the issues that you've been having. I'm going to find that you previously entered your. I'm sorry, Miss Malfino. Did you have anything to add?
No, Judge, I think that from my conversation with Ms. Cole, she's been gracious enough to offer to continue to work with her because I think she clearly sees the mental health issues. But as you can see, what Ms. Cole has been having to deal with is how the court has had to deal with Ms. Atkins today, and it's been kind of just run around circles.
Well, and in addition, I am going to find judicial notice of the court's file. Ms. Atkins was evaluated for competency to stand trial not that long ago. I think it was in January of this year. And I have that report. And the finding is that Ms. Atkins is competent, understands the nature of the proceedings, and is then just really making a choice not to follow through with what programs have been given to you, Ms. Atkins, to try to help you. So at this time, any recommendation as far as?
I have one thing to say.
Okay.
She is not giving me the information needed to follow up with those type of things.
Okay. Well, I don't believe you. I don't believe you. Ms. Cole would never say go do something and not tell you where to go or help you get there.
No, she said she does not have a list of the community service.
No.
This is the moment credibility collapses. The judge isn't weighing possibilities anymore, she's choosing who to believe. And once a court decides you're not being truthful, everything you say after that lands on deaf ears. This is where outcomes harden.
I'm worried about your community service. I'm worried about your mental health. And the fact that you're not doing what you need to, and you're still contacting the victim, and it's a serious case. And so I got to protect society, unfortunately, because you're not choosing to do the things that...
I'm going to die, so I really didn't have much of a choice.
Okay.
Is my life in jeopardy?
I'm going to find that you entered your pleas of true to counts 4 and 5 freely and voluntarily. Again, I'm finding counts 1, 2, 3, 6, 7, and 8 true. Find sufficient evidence to find you guilty, and at this time, find you guilty. Don't talk over. I'm about to sentence you to prison, and how you keep talking over me is about to start adding years onto that. Stop talking. It's just going to get worse. Do you understand? Okay. I'm going to find sufficient evidence to find you guilty, and at this time, I'm finding you guilty of injury to an elderly individual. Sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections.
This warning isn't theater. Judges can sentence within the statutory maximum, and courtroom behavior absolutely matters. Talking over the bench signals loss of control, and in cases involving mental health, that can confirm the court's worst fears. 5 years wasn't just a sentence, it was a conclusion.
You will receive credit. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. No.
I'm telling you, like she thought, like I could not get up there.
I'm going to hand you the trial court certification that shows this was.
I would like to speak to a detective.
This was not an agreement, and so you waived your right to appeal. I need you to sign that with her.
I gave her hospital papers. I gave her everything.
I'm also handed you.
I had a doctor's appointment and everything. That's what I'm.
I've got 5 more years that I could add on to that.
Oh, man.
I can give you up to 10.
Yeah.
You need to stop talking so I can finish what I need to do. Okay?
I'm telling you, I'm not guilty. That's what I'm telling you. I did not have a choice. I went to the hospital and everything.
I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition because of the judgment entered against. I'm not. Just listen to what I'm saying. If you'll listen for a minute, you'll understand. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.